First, relative to what we were talking about, what you're doing might be very helpful insofar as you see evidence of a harmony of thought across some of the fractious lines in political life, say between race or sex or geography. If you see that, but if you see, however, there's almost like people are speaking a different language. One of the anti-federalists said that's what the Constitution will do. It'll produce almost a culture in the capital that will be almost a different language from everybody else. Then it would be challenging, I guess, to those claiming that there was an original people that had the same language and had the same, moral as well as other kinds of vocabulary. Another danger, it's very problematic because it may only represent the tiny fraction of the population that write and are disposed to preserve their writings. I suspect strongly, if you look over that corpus, probably places like Massachusetts are grossly overly represented in the database because they seem to be very good at colonial history stuff. Very problematic also because it might give a sort of a counterfeit security, and I think that's what Professor Fish was getting at. Because you need to spend probably some quality time with a lot of these exemplars. You mentioned that law is different from poetry, but how much poetry is in that database already? Either people speaking in prose but in a poetical manner, or some phrase or term gets associated and becomes kind of a catchphrase, but only when used in a catchphrase manner. There's a lot of ways this can make you think. I've got the answer, what people are generally thinking, but it might be an illusion. Even if the numbers are so high. In fact, the numbers themselves may indicate that it's kind of just a peculiar, turn of speech. Enormously problematic today because if we have a constitutional amendment today, what is it going to look like? You talk about 1 million words for the internet, it's going to kill us. And it's extremely, now of course you might say, well, we got AI to catch up. That would be an interesting question. Can artificial intelligence in some sense catch up with the explosion in the data that needs to get processed? I'm inclined to say it can as well. And whatever AI is going to be able to do, it won't take the place of human intelligence, reading, looking at context, and then trying to, but you can do it with 800 instances, and that's very helpful. But it may be something we can only do with the original Constitution, and please don't find any more data, please. Don't make the database too big. That's it, thank you.
So I think this is a very interesting project, and I will not be surprised if it turns out to be a more interesting and more important project as it goes forward. I have one suggestion about what you've shown us, and then 2 quick questions. The suggestion is this. The time slice, as I read the paper, was it 1760 to 1799? I wonder about a temporal endogeneity problem in some of your analyses. That is to say, once the document, the Constitution, is released to the public, patterns in the use of words that are in the Constitution may shift, right? There is a reason to talk about domestic violence or commerce or the executive power in 1790 that did not exist in 1780. And this is going to have 2 predictable effects. One, it's going to skew uses of these words, terms, and phrases toward the legal end of your discursive spectrum, right? And 2, it's going to produce incentives among the speakers to contest and manipulate the meanings of the words. All of which is to say, you might think about whether you need to stop the time slice when the conclave in Philadelphia opens, or if you're not going to stop it there, then to think differently about what you've got after from what you've done before for these reasons. That's the suggestion. Unless you're the kind of originalists or want to be of service to the kinds of originalists who think we should also know about the stuff that came after. But that's the suggestion of which to be aware, right? The 2 questions. First, Omri Ben Shachar at the University of Chicago says that judges in the 21st century deciding contract cases that involve disputes about the meanings of the contracts should go straight to the internet, right, and ask a legion of 100,000 people who stand ready to help decide contract cases, what do you think this sentence means? A, B, C, or something else, and get an answer back, and that will decide the case. So I want to know what you think of that. And the other question is, do you think that it would be important for there to be multiple corpus linguistics databases programmed by multiple people and housed at multiple institutions, rather than asking originalists and other people who are interested, right, to use the single set of data results produced by one set of programmers at one institution.
John?
Thank you very much for the paper. I also find this project really interesting, and I have not made up my mind, I think, on how valuable I think it is. But I wanted to offer a couple criticisms or concerns. These might replicate things that Stanley said from a slightly different perspective. So as I looked into what you were doing here, it seemed to me that in some respects you're misdescribing what you're doing. There's, on the surface, a sense that the project is the use of corpus linguistic data to determine meaning. But in fact, it seems that what you're doing is using the data to confirm or support or falsify theories of meaning that are being determined on other grounds. So in your 4 examples, domestic violence, commerce, public use, and natural born, for each one can say, well, where are you getting these categories? Where are you getting the different meanings to begin with? Are you getting those from the data? And the answer is you're not. You're getting those, in one case, from Larry Solem. In one case, commerce sort of, well understood senses in the legal literature, and all of us recognize them immediately from case law debates and so forth. Public use, you go to Thomas's Kelo opinion, and natural born, again, from scholarship. So you actually are doing the critical categorization and the identification of the meanings before you go to the data. You're not inductively inferring meanings from the data in that type of a way. Your priors are doing much of the work here. Now, you are doing something. You're finding associational evidence to support one or the other of those meanings, but it's not, I think, described well as discovering the meaning in the data. Now, there's a deeper point here, which is this is exactly the approach to language that was demolished by the cognitive revolution in the study of language in the 1950s and 60s. Because the then dominant behaviorist paradigm, B.F. Skinner and others, about how people actually learned language, Skinner wrote a book called Verbal Behavior. The idea was that children are blank slates, and all of the information that eventually becomes their full competence in language use, including their semantic competence, comes from the outside. It's data that comes into the mind. Chomsky and others demolished this view in very much the way that Stanley is pointing toward, because he proved, he and others, hundreds, thousands of linguists over a multi-decade period, that it was simply impossible to draw meaningful generalizations from the data without postulating innate linguistic knowledge, or priors, if you like, that are being brought to the task of language use and are doing much of the sorting work and so forth. And again, another way to put this point is you're saying that the meaning of a word can be known by its associates, but that's not the way that everyone in this room, learned the meaning of words in the English language. We did not, in fact, infer statistically or otherwise the meanings of the words that provably we started to possess and use by age 4, 5, 6, 7, 8, on the basis of all of the prior encounters with those words in 4 or 5 word phrases. That's just not the way we learned language. So somehow our actual semantic competence is not what's being reflected in your project. We have linguistic semantic competence, but it's demonstrably not acquired in the way that you're approaching what's a similar problem of an underdetermination of theory by data problem. So that's just a really deep concern about what's going on here. It can't be really described as somehow using the data to discover meaning, but it has to be confirming or falsifying or finding support for theories of meaning that are being determined on other grounds. None of this is to say I don't think the project is valuable. I think it is. I think we can learn things from what you're doing. In some cases, probably more plausibly, and in other cases, as you point out, the results are ambiguous or not very helpful. But I do think you have to rethink the conceptual underpinnings of what you're doing and not cash it out in the way it's currently being described.
the three?
Sure. So real quick on just one point on David's comment. I still think reading in context, human reading in context is, you can't do corpus linguistics without it. It's not pushing a button and getting an answer. And the meat and potatoes of it is, we read two Harry Potter novels worth of context to do the sense coding. And so I'm not sure AI can take care of that.
Although to the extent the concern, David, is, for example, your example of what if we had a constitutional amendment today and all the Twitter data and everything else that's out there. That's actually an interesting question, because I, of course, think more about, in my day job, more about state constitutional law than I do federal constitutional law. And state constitutions do get amended all the time, with some regularity. And this problem does come up, and I think it is helpful. I think it is relevant. I've got a couple of cases under advisement right now, which I can't talk more about for that reason, but where, we have internally in my chambers have thought about trying to mine some data. I don't think you have to have AI to mine it either. These search engines, among other things, can randomize the search results for you. And so if what you have is 1 billion hits, you can tell the search engine to randomize the hits and, let's look at a couple of hundred of them and try to look at them in their relevant context. I don't know if that was the source of your concern or not, but that's just one thought that came to my mind as you were talking about that. Sorry, James.
No, that's fine. And then Richard, and I think this ties a little bit onto something that David was hinting at, and I think this goes to corpus construction, right? And a concern that, if there's just one, any errors built into that corpus, which could include representativeness, which I think you were talking about, is foist on everybody, right? And so I guess, why not? Let's have more corpora. I think one of the neat things about this initial one, which is again an initial one, and we're going to learn things, is that it was the decisions on what to go in it were already kind of made by the folks who did Evans' early American imprint series and High Line and stuff. Now, does that miss things? Absolutely. Yeah. Absolutely. We don't have a lot of writing from folks in certain classes and certain races. And
even certain regions of the country. I think the Massachusetts point you made is right.
And the goal is to work on that, right? The goal, is to try to get more balance on that over time. Let's have more corpora. Did you have anything on Richard? Or I was going to move to...
Richard's question about Amri Ben-Shahar's paper, which I've read and assigned in a seminar that I taught last semester. I think it's a really interesting paper and an interesting question, probably more interesting for statutory interpretation purposes than for constitutional interpretation, because I don't know how to do a survey of people who lived in the 18th century. But I have thought about the Ben-Shahar paper both in the context of contract interpretation, which raises many of these same questions, and with respect to statutory interpretation. And it does seem to me like there's sort of a trade-off problem. One criticism that I think has come out already in a couple of the comments in what you might try to derive from corpus data is, it is some evidence of semantic meaning, and you can try to get some pragmatic context in there, but you're not going to get enough, right? And the details really matter, and you need more pragmatic context to tell you what a given clause or a phrase means. And I think part of what Ben-Shahar is getting at in his paper with respect to contract interpretation is, we can give even more context to the survey respondent. And if what we're concerned about from the standpoint of reader or listener understanding is avoiding unfair surprise, preserving notice, some of those rule of law functions of sort of the foundations of textualism, then you can see where that paper is coming from and what that idea is based on. On the other hand, I think the big problem, which they acknowledge in that paper that you run into, is if you give a lot of pragmatic context to the survey respondent, what they may actually be telling you is not so much how they understand that abstract language, but who they wish would prevail as a matter of policy preference in the dispute that you've now told them about. You tell them about a poor little insurer in a big, massive insurance company, and wow, which way do you think your survey is going to go there? And I think that's a really interesting and a significant problem. It's one of the trade-offs that I've thought about with respect to statutory interpretation again, and I think this is a place where more thinking is going to be needed. I think there might be some circumstances where maybe if we refined the survey methodology, maybe we could get some decent data on certain types of problems of ordinary meaning of language. On the other hand, there may be other types of problems where corpus analysis is going to be better. So I hope the answer, Stanley, isn't never, never, never. I don't know how many nevers you had, but I hope it's maybe.
It's iambic pentameter, therefore 10 syllables,
All right.
therefore 5 nevers.
All right. So, and incidentally, I don't know if you want to chime in, or if you or Don, if you want to wait until we're finished responding and see if Stanley wants to chime in at that point.
Did you guys do you guys want to get to John first? And then we'll come back to
probably
Stanley?
let's do it that way.
I had a couple of thoughts with John. One, what you're talking about is a grounded theory methodology. I've got another paper written with a linguist where we talk about different ways that you could try to do sense classification based off of corpora data. And one is just you go in with no priors, or you try to, right? That's a little hard. And you just say, okay, what do we find? What senses do we, let's start classifying what we find. And we didn't do that in this paper, in part because we felt like it would maybe speak to a legal audience a little bit more to start with a legal audience's priors. But you will notice in the public use sense, we actually found a new sense that nobody was talking about. And so we were trying to be open to, is there other things that aren't, in the legal debate or in founding our dictionaries that maybe could be there. But that's, often what's going to happen is in a litigation context, the parties will be bringing the senses that they're arguing for. And then, but yes, there is absolutely a way to do it the way you're talking about it. And maybe that is a better way to do it. That's something that we can hash out. On Chomsky, correct me if I'm wrong, was he your dissertation chair?
He was on my committee.
He was on your committee. So I think maybe you overstated a little bit Chomsky's destroying of corpus linguistics. Actually, okay. So corpus linguistics tend to think of Chomsky as an armchair linguist, as someone who sits in his armchair and says, I can think up more than you can get out of a corpus. And so I think there's a debate in the linguistic world over who's right. I'm not sure that debate is over yet. I agree. We don't learn language necessarily the way that we can maybe get at meaning nowadays, or how we could get at meaning through a corpus. So I'm not sure that the fact that we don't necessarily learn language means that we can't figure out meaning in other ways. But that's something that I would need to think about more and do some more reading on. But that's actually, I think, an attack at corpus linguistics more broadly. But yeah.
Just a really quick follow-up, because maybe I mischaracterized my point. It really isn't limited to recent linguistics of the last 50 years. You could restate the point. For 2,500 years, there have been rich theories of grammar and semantics that have all presupposed, begun with different assumptions than you're using here, right? People don't learn language through big data analysis. They do it some other way, and that's what theories of language have tried to describe and explicate and capture. So there is still going to be a disconnect here. It's not about whether one linguist, we're sort of for and against what he said. It's the entire history, I think, of theories of meaning didn't, in fact, operate in this way.
Can you help me with one thing, though, John? Because I feel like there's a point here that I'm not understanding. Because what James said is what I was thinking. Why does the fact that people don't learn language using a particular tool mean that tool can't tell you about patterns of usage in the way we actually speak?
It can tell you about patterns of usage. I don't want to go on. It can tell you about patterns of usage. It can't necessarily tell you about meaning as we ordinarily understood the term and the concept of meaning. We all have rich semantic intuitions about the meanings of words in our language, and we couldn't communicate if we didn't. So there's a topic of semantics there, trying to understand our own intuitions about meaning. And what I'm saying is that seems to be quite different from what you're doing, which is patterns of usage.
So could I just, Stanley, do you want to get on this?
So I was going to say I agree with that. Remember, one of the books that Chomsky became famous for was Cartesian linguistics. And insofar as you're asking the question of why couldn't another tool, such as Corpus Linguistics, still be helpful, it's because a tool like Corpus Linguistics also has an implied, as you put it, theory of meaning. And if that theory of meaning is wrong, then it's hard to see how it's going to produce results that are going to, quote, unquote, get anywhere. The only other thing I would say that is in response to the example of, was it Madison? And you said we'd have to be stuck with insurrection?
Yeah.
Yeah, here's my point there. Suppose Madison thought that domestic violence, or somebody thought that domestic violence means what now readers of the New York Post think that domestic violence means. That's what he thought. It's what he thought that phrase meant that. You said he had badly encoded. No, he didn't badly encode. He wrote domestic violence and meant by it what 99.5% of the other people didn't mean by it, which produced a problem in communication. Now, you have to distinguish between meaning and communication, but you want to say that when he wrote domestic violence, he meant what he meant, and that the hearers, his readers and hearers, heard within the assumption of a code that was different from the code he was operating in. But I still would agree with you in the end. You're stuck with domestic violence for prudential and political reasons, because it's a default assumption that when you're listening to or reading works produced by judges or by mainstream journalists or by officials of the United States government, that it's the default assumption is that the language they're trying to speak in is ordinary public language or ordinary public meaning. Now, that assumption may be discovered, you may discover that assumption was false, that for hundreds of years we've been making a mistake. But we might decide to stay with the mistake because the results would be horrendous. We would have to undo realms of law. And remember, in the paper that I sent to you, I quote John Ford's movie Liberty Valance, when the legend becomes fact, print the legend. When the mistake is one that would no longer, when the mistake is one that, if corrected, would cause more damage than it would cause enlightenment, stick with the mistake. But it's still a mistake.
I guess I just wonder whether the reason we stick with the legend is not just for pragmatic, prudential reasons, but it's also because we care about the reader, listener side of the communicative equation.
I will say frankly, I don't give it.
This is a good conversation, but we need to move on to some others if we can. So our next triad is Freud. Yeah, Freud is Christina Mulligan, Tom Merrill, and Chris Green.
So first, I want to plus one Richard's suggestion to the extent there's an ability to influence the interface of being able to search before and after drafting, because I think your questions might be quite different as well. So this project, I think, could create a lot of good and bad outcomes depending on whether people draw good inferences from the data that's found. So I want to talk about one particular inference that you talk about when you're talking about public use in commerce, that it might say that something is a legal term of art if it appears much more often in a legal context rather than another context. So I want to throw out an example of where that might be just not true and that this might be a bad inference to draw. So, you know, let's say in a statutory regulatory context, we're regulating something with a very objective meaning, a chemical, silicon dioxide, and then it's not very interesting in the scientific or common discourse, but that statute gets wrapped up in some question over legitimacy. Do they have the power to make it? What does that part really mean? Da, da, da. And so you see this word, silicon dioxide, appearing over and over again in these legal texts and very little outside of it. But that doesn't say anything about whether that has become a legally charged word. It just means that it's something that we are caring about for some reason in a legal context. And so many of the words in the Constitution presumably would suffer a similar fate by becoming more common simply by virtue of being in the Constitution, regardless of whether they are common language or legal language.
So I just want to make a narrow point about the discussion of public use. The paper presupposes, it accepts the Thomas view that public use is, there's something called the public use clause. which is a trump on the power of eminent domain. You can't use the power of eminent domain unless it's for a public use. That understanding, it reflects a lot of conventional precedent going back some period of time. In fact, though, if you read the takings clause in the Fifth Amendment, it says, "Nor shall private property be taken for public use without just compensation." The prohibitory word appears before just compensation. It does not say, and the 19th century Lewis treatise points this out, it does not say, "Nor shall private property be taken except for public use and without just compensation," in which case you would logically assume that the public use requirement is a trump on the power of eminent domain. So what might this mean? It might mean that, the idea that you can only use eminent domain for public uses or purposes probably enters American jurisprudence in the 1830s and 40s through the influence of people like Grotius and Pufendorf. The word eminent domain enters the American discourse around the same time. The framers did not know the word eminent domain when they wrote the takings clause. So there possibility exists, and I think it's probably the more natural interpretation of the language, that what the framers were trying to say, they were describing a certain type of taking that had to be treated with just compensation, a taking for public use, as opposed to describing a limit on the power of eminent domain. So if you think the takings clause was adopted by people who are the friends of property, which is a plausible, perhaps supposition, a friend of property, if this is a description of a type of taking that requires just compensation, would want the broadest possible construction of public use, as opposed to today's understanding, which is that a friend of private property would want a narrow construction of public use in order to protect property against seizures, even with compensation by the government. So the point would be that, you've got this major interpretive question presented by the language of the clause as written, which then is sort of interpreted differently starting in the 1830s and 40s. And, before we get into this corpus study of what public use means, we kind of have to first decide what the framers may have thought public use was doing there in the Fifth Amendment.
So I wanted to push back. I'm a big fan of the general approach, but push back on the title. So data-driven originalism, maybe it's really data-leveraged originalism. So you've got one bit of text, you don't know what it means. You're like, oh, I got an idea. I'll find 50,000 uses of the same text. Well, I don't know what those mean. But of course, if you can figure out what those 50,000 mean, then the fact that there's so many uses like that. That's I think obviously going to be super, super informative, but it's not always going to be the same method that you use for all the things in the data set. So I'm a fan of dictionaries because they're giving you definitions. So one thing you could try to do, or maybe some terms, would be try to find places where ordinary people just explain what words mean. So if you can find, you've got Johnson, you've got Webster, those are two guys. Well, suppose we can find 500 people explaining what the term commerce means. So some kind of coding to describe that. Another idea, if you can find negative instances where terms are clearly being used inconsistently with a certain meaning. You might not be able to read meaning off, but you can contradict meaning. So, my equal protection paper, I just do a search through the Making of Modern Law database for protection of the laws, and I find several dozen instances where protection of the laws is being used in a way inconsistent with the Yiquo kind of reading. And also I find at one point, Blackstone says, this is what we mean when we say protection of the laws. He's giving a definition. He's not Samuel Johnson, but he's Blackstone. So Jennifer Mascott, officers in the United States, she's got a bunch of instances where she's got really, really small fry people being described as officers. That undermines Buckley. Doesn't really tell you what the word officer means, but it undermines the Buckley definition. So I just wonder, can we come up with some way to use the robots to identify things that are definition-like? Or negative, kind of negative.
Tom, you want to take those three?
Sure. Real quick on Christina. Absolutely, I think the corpus, any corpus should be able to limit on a whole lot of things, including specific years, right? You can do ranges on things. And hopefully that's going to be part of it. And I agree that just because something occurs more often in a legal context than an ordinary context doesn't mean it is a legal term of art. It may mean that. It may point towards that, but I want to investigate it more. I'd want to start looking at sense distributions. And it may just mean that it has more salience in a legal context than it does in an ordinary context. On Tom's comment, it sounded like you were getting a little bit of an intent argument. We were coding based on a public use, meaning the public gets to actually use it, or the public or the government actually owns or uses it, which doesn't seem to be necessarily a prohibition on takings. It's just who's using or owning the property versus the public in a broader sense is benefiting indirectly from it in some way. Which also doesn't seem to tap into that's necessarily a prohibition on takings or some other meaning. So we may have to talk more because I may be misunderstanding.
I think I take Tom's point that there may be some antecedent question as to whether this public use terminology, which I won't use clause for reasons you suggested, is antecedent to sort of the operative effect of the takings clause, which I think you're saying that the operative effect of the takings clause may have nothing to do with public use. That may just be a phrase that describes the kinds of
Framers were looking for a word for what we would now call eminent domain, which is a type of taking different from an accidental taking or different from a forfeiture or a seizure of property for a criminal fine or something like that.
Right, and what I was going to say about that is, if I'm understanding this point, and James, feel free to jump in here, but it seems to me like maybe this fits into the category of possibly a structural ambiguity as opposed to a lexical ambiguity. So our point as to at least the kinds of problems that so far I've been able to think of how you could use corpus data to resolve problems of ambiguity in legal texts, they fall into the category of lexical ambiguity, a polysemous term that has multiple meanings in a dictionary, as opposed to what is the syntactic function, what is the structural function of a given phrase in a given clause. Maybe somebody who's a whole lot smarter than we are can figure out how to leverage corpus linguistics, better in the future to answer some of these other sorts of problems. But it may be that that's what you're highlighting, and maybe we ought to caveat that and sort of focus on that. It also seems to me the other response, I guess, sort of fits into the category of we are kind of accepting at face value the approaches that have been advocated for in the cases. So maybe it's right to say, whichever one of you noted earlier, maybe this was John's point, at most we're sort of falsifying as opposed to establishing meaning, but at least that's a step, I think.
Does that speak to Chris too? Is that
No, I had a couple quick things for Chris. I like dictionaries too, and in fact, modern dictionaries are actually created via corpus linguistics. That's how lexicographers operate today. So to the fact that corpus linguistics is problematic for finding meaning, as John seems to indicate, then we may have a problem with modern dictionaries. Frequency is a tricky thing, and frequency can be misused. I like Jen's work, but and I'm actually working on a similar paper right now. And one of the problems with factual frequency, though, is it starts to get a little tricky in that. So let's say we looked at officers of the United States and found out that usually we're talking about governors and attorney generals, and every once in a while we talk about a clerk. Well, there are certain folks in society we talk about more. So does that necessarily mean the clerk's excluded because we talk about governors and so much more often that's the ordinary sense? I actually think that's a whole different thing. I think that's like, bird. We talk about robins and canaries a lot more than penguins. That doesn't mean a penguin's not a bird. But it's a complicated linguistic thing that there's lots of fights over. Prototypicality, right, that's starting to get into prototypicality. And I'd push back on the robot thing. I actually think of this as more as like a golf club. I think of the corpus as a golf club, that it's the human, the golf club magnifies the human, but it doesn't replace them. So,
Stanley, did you have anything on?
Oh, no, I was just going to add that when I read this paper, one sentence, this sentence occurred after the analysis of commerce, manufacturing, and trade. One sentence terrified me. It is, further research could be done.
Further questions can certainly be asked. So we have Mike Rappaport and Judd Campbell and Mike McConnell.
So This is a very modern project, and it's sort of interesting to ask about, can this very modern project be used towards originalism? I suppose one way to think about the question is this, the way I would think about it, is this consistent with original methods? Originalism, I mean, it brought to mind, Jack says, well, public choice theory. The framers didn't have that, could use that, so on and so forth. There's sort of interesting questions here. So when I think about this question about things that they didn't, that the framers didn't, let's say, have rules about. They certainly didn't have a rule about corpus linguistics. Sort of have to ask yourself, but the first question one would ask is, did they explicitly permit a certain kind of analysis? Did they prohibit a certain kind of analysis? And if they didn't have a rule one way or the other on that, and they were silent on it, one then has to go a little bit deeper. So a similar kind of issue might come up with respect to legislative history, right? So if you think, and not everyone does, but if you think that, say, the original methods were original public meaning analysis, and they didn't really have a practice of going into legislative history because there wasn't much legislative history, is it okay to look to legislative history? And one kind of answer you can give with respect to legislative history, it's okay if the reason you're looking for it is to establish the meaning as opposed to look to the intent. So my take on this would be, as a sort of first take, is that since we don't know the language very well at the time, we need all the help we can get with understanding the 18th century language. And if we're looking towards the meaning, and this is helping to establish the meaning, that this is a permissible thing to do as a way of figuring out the meaning, unless one can conclude there's some reason to think that the original methods might sort of implicitly prohibit it. Now, to pick up on that line, let me contrast this with using corpus linguistics for a modern statutory enactment, right? Where I think the question is more difficult, right? Because so you might think, oh, well, we have a modern statutory enactment, we all know the language. And in fact, this was expected to be interpreted with respect to our linguistic intuitions. And if corpus linguistics would give us different answers than our linguistic intuitions, and I don't know if it would or wouldn't, but if it would, one might begin to say, oh, well, this is a different method than was deemed to be applicable to the statute. So it's not an empty question to ask whether or not it's permitted or not. I don't mean to suggest that corpus linguistics is impermissible for modern statutes, but I just think it's a different question, or a little bit of a different question.
Yeah, so I wanted to build on James's last point, which is thinking about commerce. Take your last insight and apply it to commerce. We don't know anything from your paper about the relative uses of the words trade, production, or how often those sorts of things are being discussed, how often it makes sense to discuss those things in relation to commerce. And so we actually need to know a lot more about the economic world of the founding before I think we can draw any conclusions here. Same thing about public use. If public use is primarily used in relation to takings, we need to know about government practice with respect to takings. Is the government in the enterprise of doing things for the general economic benefit of everyone without retaining the property, or do most takings just so happen to be takings that the government then possesses the property, and therefore it makes no sense to use public use as a term for a broader set, not because it doesn't mean that, but just because the government isn't doing that sort of stuff. And the other thing that I'm thinking of here is, does your data help us at all with sort of levels of abstraction problem? It seems like a lot of times when we have constitutional interpretive debates, we're worried about, does this word, not what does this word mean, but does this word stand in for some broader principle? So, sure, the literal, Stanley hates that word, but the literal meaning of commerce, or say the most common meaning of commerce, might be just trade, but maybe filtering that through some interpretive device. At the founding, we know that the founders were construing constitutional language in a more each word sort of exemplified a broader concept. And so I wonder, that's not to say your method isn't useful, but I wonder is there some way that we incorporate that sort of move within your method, or does that just sit on the side as a limitation of it?
Michael. So I don't have any theoretical problem with this, and although I want to think about what Stanley has said, which is extremely interesting, but what I'd really like to do is try it out. Maybe I'll borrow your password and something that I'm thinking about, see if it actually does me any good. I'm a little skeptical that it's going to do me any good. And so part of it, what I've been doing, in reaction to the paper is just to think of an example or two. So commerce and navigation. So was Gibbons versus Ogden right? The reason Gibbons is a question is when you have navigation in the absence of the buying and selling of goods, is that commerce or not? And so now we know, thanks to page 32 and around it, that the words commerce and navigation very frequently occur close together as a cluster, right? Or a as a colloquy, rather. So I'm thinking, okay, what does that tell me? And I guess I don't think it tells me very much, because sometimes when you have words used together, it's because it's necessary to mention both of them because they're different. So to make sure that maybe navigation isn't understood to be a subset of commerce, and that's why you need to say commerce and navigation a lot whenever you want to refer. But sometimes, when words are used very frequently together, it's because they're essentially the same. They may even be synonyms, or at least they're very close. And what I would really like to know is how often is the word commerce used to include navigation without using the word navigation? And there's and that's really going to tell us what we're interested in knowing. And this doesn't help. Is that a general problem, or is that or did I just pick on an example that happens to make it look as though this doesn't help?
Technically, we're over time, but we started a little late, and so with the recognition that the time is out of joint, brief responses.
I don't know. I think the great thing about this tool is that everybody can start jumping in and start looking. And I think to the extent that commerce may be a term of art that sometimes includes navigation, perhaps the corpus can shed some light on that to the extent that I think this is going to Judd's comment that I think he had a similar point. Maybe the founders were using commerce to mean something broader than commerce. Well, perhaps if the patterns in the founders portion of the corpus differ significantly as far as what we're seeing on senses from the other mini corpora, maybe that'll start shedding some light. I think what's fun about this, though, is you don't necessarily have to take any of our word for it, is that you can start jumping in and start looking at this yourself. On the public use thing, it was almost never used in the context of takings from what we saw, just FYI. But you can find that out for yourself.
I'll try and be really brief also. I think, Mike, your question is interesting. Whether a tool that would have been completely foreign to the 18th century, whether we can use it now, is that consistent with original methods, originalism? I don't know. Even though that seems like an interesting question, it seems, the more I think about it, sort of like a silly one. I mean, in the founding generation, they were doing math. If we needed to do a math problem today to decide a case, can I open up my calculator app, or do I have to do it in my head? I mean, what Corpus Linguistics, and I think this is where you eventually ended up at the end of your question, but what Corpus Linguistics is doing for us is giving us a very modern tool that's data-backed to decide questions that we've been deciding for a very long time. And I think maybe this also fits into the the question about whether we can do this with respect to statutory interpretation. I think what you said there was when we enact statutes, it's because we expect the words in the statute to be consistent with our sort of modern intuition about the way language is used. And what do we do if the data we get out of a corpus is inconsistent with our intuitions? Well, I think maybe I'm missing your question here, Mike, but I think that's sort of the whole point of the inquiry into the data. And I take Mike McConnell's point, which I'll get to in a second, which is I don't know how many problems this will help us solve. I am very skeptical that collocates are ever going to tell us much. I think maybe frequency of the distribution of various senses with respect to a problem of genuine lexical ambiguity, which is why domestic violence, I think, is a useful example for us to use. That seems much more helpful. But with respect to your statutory interpretation question, Mike Rappaport, I guess I just don't, I don't see the disconnect there, because if one of the motivations for this project is the way we're handling problems of meaning with respect to text today is very intuitive, and what you often end up with is one majority opinion saying, take my word for it, this is what the language means, and a group of dissenting judges saying, no, I think this is what it means. And so what do we do when our linguistic intuitions don't quite match up? If you can get good data, and it's a big if, and there are all kinds of unanswered questions, I think, about how to get good data, then we ought to trust the data, and it ought to sort of falsify our intuition, if we can get the good data. I think there was one thing I was going to say, Judd, in response to your question. It seems like maybe what you're talking about maybe relates to something that Larry Solom says in a recent paper about, I think he uses the terminology of triangulation. When he's talking about corpus linguistics, he's saying, look, this is one piece of the inquiry. Another piece of the inquiry, if I'm remembering the term right, is immersion. We need to be able to immerse ourselves historically into the language and the culture in order to, and so I think that's a very fair point, and I kind of liked Larry's way of putting it, that this is only one corner of the triangle in terms of our inquiry.